The government has announced its long-awaited plans for abortion law reform, which would no longer make it illegal in New Zealand. After months of stalling and negotiation, Justice Minister Andrew Little has landed a compromise to allow women to have abortions without a statutory test before 20 weeks. Abortion Rights Aotearoa welcomes the draft reforms that would remove terminations from the Crimes Act. ALRANZ National President Terry Bellamak joins me now. Good evening to you, Terry.
Hi, Alex.
Can I ask you first if you're happy that this is going to a conscience vote in the Parliament?
Well, conscience votes can be a little tricky, not least because it's certainly possible that MPs do tend to be a bit more conservative than the people at large. Consistently over the last year, polls have shown that 2/3 of the New Zealand population supports abortion under any circumstance. So the people pretty much know what they think. We need to figure out what the MPs think.
Okay. And then in terms of what you think, we've seen this bill just today from Andrew Little. In what way, I suppose, are the reforms limited in any way, in your opinion?
Well, we were hoping that the Justice Minister and the Cabinet would select Model A, because Model A is the one that treats abortion like healthcare, which is what it is. It's unfortunate because it's unfortunate that they went with Model C or a version of Model C, because really the pregnant person is the person best placed to determine what's best for her and her family. So after 20 weeks, as a result of the one that they picked, that question goes to a qualified health practitioner who's going to make the decision for her.
It's a huge change from the status quo, though, isn't it, in that sense?
Very true. Very true. Compared to the status quo, it's a huge improvement.
I wonder whether you think it might also be limited in the sense of talking to broader healthcare and concern for women and support. I note that it doesn't talk too much about counselling services, and we hear a lot about this. We hear about choice and we hear about coercion around abortion, and on both sides. It's a very, very heated debate, as you and I know very, very well. So do you think that there could be a bill that, I guess, guarantees that women really do have choice, even sometimes when they're coerced by their own partner or husband or family members to have an abortion?
Yeah. Well, reproductive coercion is something that's really applies to both, being coerced to continue a pregnancy or to terminate a pregnancy. Now, being coerced to continue a pregnancy is something that nobody really gets a look in, because you don't have to go to a doctor in order to keep that going. Abortion coercion, however, is something that the health system can actually pick up on, because they have to be talking to people. And actually, it's something that in the past, our current abortion system, takes that into consideration quite a bit. Informed consent is kind of a big deal in medical circles. And I could point you to some doctors to talk to about that. But doctors take it very seriously, and it's part of their job, according to the law, that they have to make sure that their patient understands the condition, the possible treatments, and also in the case of abortion, generally, actually absolutely every time, they'll get the woman off apart from her support people so they can talk to her, just her alone, just to make sure she's not being coerced.
Hey, Terry, I wonder also, there's a whole lot of other things that are in this bill, and we don't have too much time. New sections 19 and 20 deal with conscientious objections. So I'm sort of asking this question with the whole euthanasia bill in mind, because there's a section in that about conscientious objection as well. And it seems that those who object to these procedures want to keep their conscientious objection intact. And they would argue that having to refer the person on or telling the person where they can find those services still does conflict with a conscientious objection. Do you expect some sort of pushback to that element of the bill?
There may be pushback, but I don't think it's really a valid issue. I think our current conscientious objection system is really, it burdens the patient so much more than the doctor. It's really out of balance. We would like to see a much more balanced system, and I'm not even entirely sure that what the new draft bill is proposing is sufficiently balanced to really protect patients from the burden of their provider's conscience.
Yeah, because it's saying at the moment they must state their objection and tell a person how they may access a provider of the service requested. You're saying they should be forced to do more than that.
Well, what I would really like to see is a list of providers who refuse to provide certain services and what services they refuse to provide, and to make that list available to people who are searching for a doctor so that they know beforehand what they can't access through this doctor.
Look, we're going to have to call it quits there. Thanks, Terry. Thanks for your time. From the National President of ALRANZ, looking for abortion law reform in New Zealand, responding to Andrew Little's announcement today that they will be removing abortion from the Crimes Act.